class action lawyer Richard Spoor and his firm says he's now adding the international miner and commodities trader Glencore to the list of companies it's pursued to help miners who are suffering from silicosis. His law firm says miners are suffering from the lung disease as a result of the work they did underground for mines owned by Glencore and because of the way they were treated. Chloe Hoffman is an associate at Richard Spoor Incorporated. Chloe, good afternoon to you. Why are you now adding Glencore to this list? What do you want from them?
Hi, Stephen. Yes, thank you so much for having me. If I could just make a correction, we are pursuing damages for pneumoconiosis and COPD, chronic obstructive pulmonary diseases. They fall within a category of illness called coal mine dust lung diseases, and these are the lung diseases that you contract from coal mining, as opposed to silicosis, which is contracted from gold mining. So we have added Glencore to 4 class actions that we've launched. Previously, we've launched class actions against South 32, Anglo-American Group, Exxaro, and Glencore. These are simply the biggest role players in the South African coal mining industry, and by virtue of that, our class actions have the ability to reach as many mine workers as possible.
Thank you for the correction. I appreciate it. How many miners, how many people could be affected by this?
So it's difficult to say. That's the very nature of class actions. We are aware that this is a prolific problem. It's something that is being suffered by countless mine workers. We have consulted with outreach to almost 10,000, I apologize, 1,500 mine workers. And just by virtue of that, we are of the view that tens of thousands of mine workers will be potentially compensated by these class actions.
Was Glencore the owner of these mines at the time, or did it buy them later? And Chloe, this can be a big issue about who really has responsibility. Mines do change hands to their working life. Did Glencore own the mines at the time?
Yes, so thank you for that. It is a very important point. So for sort of ease of reference, we refer to these class actions by the biggest role player that we're citing in our papers, but they're not in fact the only role players. There were, as you've mentioned, so our class period runs from 1965 to date of certification. So the mines that we are dealing with and that we are seeking compensation for have been owned by different companies. So each company that has owned that mine during that time will be cited as a respondent. So it is our responsibility to track the ownership of the mine and to cite the companies that had control ownership over the mines at the time when our mine workers were falling ill.
It could be that some of those mining companies no longer exist, and you know how people structure things, Chloe. They make sure that they're judgment-proof. In other words, the ownership now vests in a company that has no assets, or someone else has made off with the money.
Mm-hmm. Absolutely right. It is a problem that we're encountering. So for the most part, we've been fortunate enough to be able to cite respondents who are still in operation. But there are 1 or 2 in particular from the South 32 group and, in fact, the Glencore group who have started withdrawing from the South African coal mining industry, which has led many of their companies to either be wound up or liquidated. And in those circumstances, the information that is available to us about why those companies are going through dissolution processes, they're not well known. So in the course of our class actions with the companies that appear to be, by virtue of their CIPC registration, going through some sort of dissolution process, we will be making interlocutory applications to reinstate those companies on the company register so that we can pursue these actions against them. But it is certainly a complication in our class actions. Also, by virtue of the fact that we're talking about quite a significant class period from 1965 to date. So there are companies that, in fact, just by the effluxion of time have closed, etc. But our idea, our game plan in respect of those companies is to seek a reinstatement of those companies on the basis that we set forth in our papers.
To go back all the way to 1965, you're talking about people from that era. I'm sure all the miners underground at the time were men, who are probably around 80. I mean, some of these people are fairly elderly, so for them, the timing of this is really important.
Absolutely. Stephen, I think it's a really important point that you've made there. Many of our class representatives and other people who we've consulted with that will form members of the class are well within their 60s, into 70s, into 80s, and you can imagine the impact that lung diseases, very severe lung diseases, are having on their bodies. I have consulted with a class representative who at this point is immobile. He's unable to move because his body cannot circulate oxygen. And just by virtue of that, he does not have access to the very basic medical interventions like oxygen tanks. And it's that we're seeking to redress. We're doing our very best to help the people who worked in the mines underground, built our country effectively, and we need to be taking care of them.
You're working with a big American firm. It's called Motley Rice. Now, our law is quite different to American law. They do class action suits all the time. It's how John Grisham made his money, writing about them, not doing them. But we don't have law like that at all, actually. A class action suit is a very new thing here. What help are they giving you if our law is so different to theirs?
So particularly guidance in respect, they are very specialized, as you've mentioned, in class actions, but also personal injury actions. They have been invaluable because, as you've mentioned, class actions are a particularly new legal mechanism in South Africa. We don't have a statute in which we can follow. It doesn't have a procedure that's set out. We, alongside the courts, are effectively creating class action legislation in South Africa. And sometimes that requires creativity. Sometimes that requires proposing new processes, new procedures, new mechanisms within the class action system to have these matters go forward and work in an effective way. And Motley Rice has been invaluable in that respect because, of course, they have run class actions. Although they have legislation and they might work a little bit differently, we still have lessons to learn from them. And their opinions, where we've needed some creativity, have really been invaluable.
Did you say lawyers have creativity, Chloe? In the past, the big victory that your firm, Richard Spoor Incorporated, won was in the gold mining industry. But if I remember correctly, they settled. Are you aiming for a settlement here too? It would save everyone a lot of time and money, but there might be reasons why the current owners of these mines refuse to settle.
Yes. So look, settlement is always a consideration for us. It is... Class actions, as we've already mentioned, as we have already discussed, are pretty complicated. We don't have the settled law. Things take time. Our South African courts are overburdened. So it is, when you're looking down the barrel of a class action of this nature, it is potentially 5 to 10 years. And as we've spoken about, many of our class representatives and other members of the class don't have that amount of time. So settlement is always a consideration from that perspective. It is something that will always be compromised, as settlement is in any legal proceeding. But it does allow for certainty. It does allow for some sort of immediate relief for our clients. I must note, almost every respondent who we've cited in these class actions, Glencore is still a little bit premature, but in the other class actions, each company has submitted notices of intention to defend. So it does look like we will be proceeding with the class action, with the certification application, but we do hope that the companies begin to see the content of our supporting affidavits that have been deposed to our class representatives that show how much they are suffering, and the role that they played in that suffering needs to be acknowledged, and we're hoping that they will reach that point.
If you go back to the gold case, I've heard from some mine workers there who say they didn't get the money they believed they were going to get. And I realize each claim would have to be made and have to be verified. What process was used there? If I remember, you actually set up a trust, and that trust paid out the money.
Yes, that's exactly right. So in the silicosis litigation, ultimately the settlement led to the formation of the Chiamiso Trust, which we as the applicant attorneys aren't allowed to have much role or say in, unfortunately, just by the sort of keeping us removed because we do have a vested interest in it. There has been some difficulties, some delays in the paying out of the Chiamiso Trust. We are in the process of working alongside Lawyers for Human Rights and Abraham Kivitz, which is another law firm, in which to try to address the difficulties that the trust is facing with the payouts of compensation. And I do believe that we'll get a little bit, we'll improve the process, we'll get there. But as I mentioned earlier, the creativity, we've recognized and seen some of the difficulties that the trust is facing. So this formation of a trust in the current coal litigation is actually cited in our papers as an alternative. We have suggested instead for the imposition or the appointment of a special master, which effectively will fulfill the same role as what the Chiomiso Trust does for the gold litigation, but it has oversight by the court. The court remains in a supervisory controlled position over that special master, which we think might be a creative mechanism in which to resolve some of the difficulties that have been encountered.
Chloe Hoffman, thank you, and Associate at Richard Spoor Incorporated. Really do appreciate the time.